Hello and welcome. Well, psychiatric patient gets 10-year jail term in probably a record time. But I say from Dadia Swaba with the mission. There are so many questions than there are answers. Now, one school of thought says that this gentleman, Charles Entry, may be suffering from some mental challenges, judging from his demeanor. The other school of thought is saying that, no, hold on. If this guy came from Dadia Swaba, came to stay here for 3 days, managed to find where the president worships, managed to buy himself a gun and snoops in and out of this church, then he must have known what he's doing. He must be calculated. Maybe he's pretending. Which is which? And either way, he gets to court with no representation, and within no time, he's been handed a 10-year jail term. Folks, in order to find out this, I have in the house one lawyer and one guru in psychiatric medicine to find out, indeed, is this gentleman suffering upstairs, and legally, has he been handed fair justice? I have with me Dr. Barima Osei, and I have with me lawyer Yao Opong, legal practitioner, and they're going to try and explain to us what really happened. Is it indeed that's what we need in this country? Aren't we fed up with all this bureaucracy? You and I keep saying that, oh, Saturday, nobody ever gets jailed. This time somebody's getting jailed and we are complaining. Which is which? Folks, my name is Nana Sakwao and this is PM Express. When I come back, we're going to watch a couple of inserts of what happened, after this gentleman was arrested, and then the conversation will begin. You don't want to move. We're coming straight back. Well, so we're going to have a couple of inserts, and then we'll watch this inserts just to set off our discussion. So, there we go. Do we have the inserts ready?
What you did to cause the death of Atamels can cause the death of Mahama.
No, that is not possible. That can only happen if Mahama is dead.
Mandela called prison by and president.
When you return from prison, you can become president. Mandela became president after 7 terms in jail. You can equally become president after 7-year sentence.
De minimum in our Kobe night. Ma, bisa me send be familiar. Ma, make candy minimum. No, status on Bisa Minuan so. Timinuan Bissemo, no, drew baby, Anna, Minuan and 70 being Timinsis so. Ama Biana from Pennyphone, no master be Selenia Jadi. T. A Coba say, Omo a nipa come on your co village one Casanom Kuhun, the rare family, a bantin if femini who say a beer alleyway. T. A mammy be enough for co village, Abraham for Naiko Bishia, and a crumum from Pennyphone be motor union for Mominaji to Mose. Yes, I want so. Dear by a chino, and a be enough on James say, the BCB are number frame. To say yes and ra, meditation a jelino.
So the family communicated to the BNI that your brother had mental illness.
And yes. I want you to, I be sure you to, Omokachi BNI for sir.
Did any of you represent him in court? Were any of you at the court when the hearing of the case was ongoing?
No, we shouldn't be anyhow. We shouldn't be anyhow.
So, what?
Well, I mean, a brother of the 36-year-old man convicted after he attempted to assassinate President Mahama says the BNI had informed Charles Entry, had been informed that Charles Entry had previously been treated for mental illness. Charles Entry was arrested last Sunday for carrying a gun to the Ringway Gospel Center branch of the Assemblies of God Church, where President Mahama and his family fellowships. He was jailed 10 years yesterday without a lawyer, and some lawyers are criticizing the trial judge for violating the suspect's constitutional rights. Now, prior to his sentence, the prosecution had told the presiding judge that Charles Entry was mentally sound. But his brother Kwame Puku, with whom Charles lived with before the incident, has exclusively told Joy News he led officials of BNI to Tafo Government Hospital, where the convict had previously sought treatment for mental illness. The big question we are exploring today is the flaws in the legal process leading to his trial, and what work went into decision to jailing him for 10 years. Now, Dr. Akwesio says in the house, so I will start with you, Doctor, who's obviously chief psychiatric doctor. Doctor, this guy lived at Dadie Swaba. Travels down, comes to stay with his brother. According to his brother, he even bought himself a taxi, used it for a couple of days, and then stopped using the taxi. Well, because he kept saying he was going to kill the president, so I think the station drove him out of the station. He, according to him, met a Burkina Faso gentleman, bought a gun off him, managed to find the president's church, attends there 3-4 times. He's calculated. Is he just now trying to portray, oh, you know, I'm a lunatic, don't take me into a jailhouse, but take me to a hospital? What could be happening?
Well, thank you very much, Nana, and good evening to viewers.
Good evening.
Well, let me say that I've not seen the patient or the person.
Sure.
And therefore, what I'm going to say is largely based on the snippets you've had from the media.
Mm-hmm.
But given what happened, as the media you have told us, this man obviously had a mental illness, and he needed to be assessed before further court proceedings. Why do I say so?
Mm-hmm.
This is somebody who says that he was involved in the death of President Atta Mills. I mean, we all know the circumstances leading to the death of the former president, the late president. And he says he knows something about it. He was part of the cause. That already should arouse anybody's suspicion. Then he goes on further to say that when the president died, he was expecting to be installed. And instead, President Mahama was installed. I mean, again, that does not fit. You are not part of the presidency. You are not the vice president. You are nowhere near the seat of power. And you are expecting that once the president died, you should be installed. And then the President Mahama is there, and you say that, oh, I want to kill him so that I will be. I mean, at the church, you want to kill the president in the church house, and then, not so much the church house, but you kill him there, and then become the next president. That obviously does not fit. Now, these pronouncements alone, even without the benefit of any history, any information that we have about him, this alone should arouse anybody's suspicion that the issues don't really fit. And as the brother was narrating, some of the things he was saying caused the laughter amongst the policemen and the court and everything. So this obviously should tell us there's something wrong with this guy. That alone is enough. And now you go further, you hear what the brother, the mother, they're all telling us, that he's a known patient. He's been to Tafo, Old Kumasi Tafo. He's been to town also. All this. So there is no doubt that this person has a mental illness. But what many people ask is that how could he be mentally ill and yet to have been able to calculate all that much? This is the general misconception about mental illness. We tend to think that if you are mentally ill, you are totally 100% off. That is not true. Indeed, if one had the courage to approach any of those vagrant or mentally ill on the streets, dreadlocked, dirty, even naked, you had the courage and ask him questions or converse with him, you'll be amazed at the kind of conversation that you could hold with him. Very intelligible throughout. In the same way, somebody could be mentally ill, and yet he may be dressed neatly, nicely, everything, and therefore you will not suspect anything, but just engage him in conversation, what comes out, immediately you realize there's something wrong. So the mind has various faculties, and if the particular faculty involved in a particular action is not affected, everything else may be affected or maybe in its disarray, but that function itself may be intact. And so the fact that he's planned all this one does not mean he can be mentally ill. Everything shows that this person needed to be assessed, and that's the bottom line.
Look, I know I can understand what you're saying, but is it not too extreme that you can have, somebody so, deranged on one aspect, but, 100% on the other? Can't the other also be a bit faulty?
A typical example I give is that we have the nose which smells. We have the eyes which see. We have the mouth that talks. We have the heart that beats. So various organs. Now, if you are impaired in one organ, it doesn't mean the other organs are impaired. So if you are visually impaired, your nose is there, your ears are there, you hear. If your ears are impaired, your eyes are there, you see. In the same way, the mind also acts in a similar fashion. The mind has different components, and each component controls one aspect of our life, of our behavior. So there is a portion of the mind that will control the way you dress. There's a portion of the mind that will control how you speak. There's a portion of the mind that will control various aspects. So if the portion that controls this aspect is impaired, other aspects are there. And that's the point that is important for people to recognize. So if you are mentally ill, it doesn't mean you're totally wrong. Let me give you a typical example. How come that somebody is mentally ill and a vehicle is on the road and a vehicle is coming and will recognize that it's a danger and will get out of the road? Does it mean if he's mentally ill, then he should not recognize that it's a danger? No. People have been asking, how come somebody may be mentally ill and probably may have a sexual urge and can go and impregnate somebody? You are mentally ill. That doesn't mean every aspect of your behavior is gone. It doesn't mean that.
Doc, so if such a patient came to you and he says, no, if I can prove to Doc that I am mentally ill, I won't be sent to prison. So he's probably going to come and sit in front of you and still give you funny answers and silly answers and say, yeah, I'm going to be the next president and this and that. And then you say, oh yeah, this guy is not well. Don't take him to prison.
Well, again, that's how we function. That's where the professionalism comes in. So it's not that you pretend, you come and you pretend that I'm mentally ill. You say, yes, you're mentally ill. I can give you, we have had a lot of instances. Some people pretend, no doubt about it. People can pretend to be mentally ill. And if they pretend, you'll catch them. Because we are trained to be able to recognize that. There was a time, some time back, somebody came, he had been to the court, and he eased and spread it on himself, pretending to be mentally ill. So they brought him to the S, all right. And when he came, stuck naked, about 28-year-old man, completely naked, and then he would spit onto himself and take it with the fingers and move in a certain manner, and then he would Now, the simple method was that the manner in which he was portraying he was mentally ill, that manner didn't fit into any known pattern of mental illness. We recognized that this person was feigning. We sent it back to the court for the court to take further action. He was imprisoned. In prison, he colluded with other inmates, and they dug a hole in the wall. And this was at some time back. He dug a hole in the wall, and at the time they were digging the hole, they were clapping and shouting, and so the prisoners, the warders, thought that, oh, maybe they are singing, they are praising. So when they finished and there was silence, again, they thought, oh, maybe they are sleeping. They are tired, they are sleeping. The next day, they went there, zero, nobody was in the room. They had sneaked through the wall, through the hole they had dug. This guy was eventually caught at a floor border anyway. This was somebody who was very clearly well, and he was pretending. So the point I'm making is that it's not enough for you to say that, yes, I'm mentally ill, and then you say, yes, you are ill. We know how to assess you, and that's where our professionalism comes in. So we can catch you if you are pretending.
Wow. Upon this would go down in Ghana's history one way or the other.
Yes, that's right.
And we've had a few, legal brains say that, look, it was too hasty and there's something not right about it. Are we saying that between the police, the BNI, and the court, nobody suspected anything at all to say, let's just go and check? I mean, even if he's pretending, just make sure he's just pretending.
Interesting. Well, good evening. But I would like to support what Doctor said, and in answer to your various questions, that the law itself has provided for the elements to identify, to convince the court, or probably even the expert to examine him, whether or not the person is suffering from some kind of mental disorder or derangement which has affected him, and therefore makes it a defense which is available to him. So Section 27 of what used to be the Criminal Code, or the Criminal and Other Offences Act, it says when a person is accused of crime, the special verdict provided by the Criminal Procedure Code in the case of insanity shall only be applicable if he was prevented by reason of idiocy, imbecility, or any mental derangement or disease affecting the mind from knowing the nature or consequences of the act in respect of which he is accused, or if he did the act in respect of which he is accused under the influence of an insane delusion of such a nature as to render him, and this is important, in the opinion of the jury or the court, and probably I will say the expert, an unfit subject for punishment of any kind in respect of such act. So it is not just a mere identification of mental derangement or disease or delusion, but it should deprive him of the ability to understand that his act constitutes an offense, and also that it should deprive him of an understanding of the effect of punishment. First, the punishment itself. Because if the punishment, he will not know that he has been punished by the fact that he is suffering from a mental disease, then the punishment would not be necessary.
I see.
So those two things will also guide it, not only the court.
And that doctor would have to determine.
And that is where then you have to be referred to the certified doctors, and then they will return that their opinion. And I mean, the general position is that the court may not even be bound by the expert opinion, if in the view of the court, probably at the time of the offense or at the time of the trial, he was able to convince, or what he said convinced the court that no, this is not a defense that should avail this particular person because of what he has told the court, his demeanor and all that. It can be problematic, but that is, so it is not just enough to say that I'm insane, or as usually they will permit me, is a madman. No. Is it capable of depriving him of the ability to understand the nature of the offense and also the punishment? That is important. Then to your question directly, well, I will look at it in two ways. I mean, first, the procedure, which is also law, and the substantive, that is the punishment, if I may say so. Now, first of all, I think there are very few principles of law that I believe are settled. And even those that are settled now can in future be unsettled, if you like, or be replaced in future based on some circumstances. But one of them is that when an accused person pleads guilty to an offense, then there is no duty on the prosecution to now prove his guilt, generally, except usually, for example, in a murder case or even treason. But more importantly, where he pleads not guilty, then there is no duty imposed on him immediately to prove his guilt or to say otherwise or incriminate himself, as I understand it. It then becomes a duty of the person who has brought him before court that his liberty should be curtailed to convince the court, and we say the standard largely is beyond reasonable doubt, why his liberty should be curtailed. Simple terms. And so, if what we're hearing in this case is indeed what happened, that, for example, and he was charged, the charge sheet was read. And it's interesting to note that you will see the original charge, the original statement of offense having been cancelled. And then there's a pen that is used to write another provision under it. And when I looked at it, well, I'll reserve any other comment on it. But in such an official document, in official setting, you expect that at least there will be a signature that is inscribed against it, so that anybody, and probably even write your name. But that is beside the point. Now the person is charged under the Arms and Ammunition Act, NRCD 9. And NRCD 9 clearly spells out the offense that it should be and the punishment for it. I will reserve that. So going by the procedure, once he said, I am not guilty to the charge you have read to me, which is possessing arms or firearms without lawful excuse or without authorization or authority. And he says, I am not guilty. That is it. It is then for the prosecution to prove to the court beyond reasonable doubt that, no, he is rather guilty. It is true, and I'm convinced that when the person says, I'm not guilty, it doesn't mean he's innocent. It is for you to prove that he is guilty. All right? So, if that is what happened, then it beats my mind, and it becomes a bit strange to me that from what we've seen and heard, subsequently, there is information that, and that is what we call plea.
Yeah.
So his plea was taken. There's information that plea retaken. Because the little we know about this system is that at that point, then the court will enter a plea of not guilty and then ask the prosecution. For me, it doesn't matter whether it's the same day. I mean, yes, as they say, justice delayed is justice denied. Of course, others will say justice buried is justice hurried. But whichever way you see it, there is no law that says that when a person is charged before court, he cannot be tried that very day. Even though, when you read Article 19(1) of the Constitution, it says, person shall be given a reasonable period within which he must defend himself. All right? So, but that doesn't mean that the prosecution cannot bring the case against him on that day, and then he is given the opportunity to respond within a reasonable time. What is reasonable is itself a matter of fact, determined on case-by-case basis. So that is the first problem that I have, that why was this still prevailed upon? If what we are saying is in fact what happened. And then eventually, he incriminates himself, as it were, to admit a different kind of offense, so to speak. For example, preparation to commit an offense, for example, which is an offense anyway, when it wasn't what he was charged with before the court. And that is where, then when you examine the reasons given and the judgment itself, the conviction, you then understand why the particular judgment or conviction was rendered to him. Or
is the judge obliged then to say, hey, hold on, Mr. Entry, where you're going is dangerous waters, and therefore don't say that, or you may need a counsel here, or the judge cannot say anything?
Oh, well, I mean, in court, I have been asked, in fact, I've been compelled, and every lawyer can be compelled in the courtroom to defend an accused person. It's one of the instances where you don't even have the discretion. Whether you've been attacked by armed robbers before or not, you will do it and do it to the end, to the best of your ability. So in a situation like this, I think that appropriately, I understand at least there was one lawyer there. That's why the court insists that at any point in time, if you go to court and there is you are the only one, when you finish, you don't leave the judge. You wait, because you never know where a situation like this, for example, may occur. And then the court will ask you to defend that person. It is the duty of the state, at least in court, even where the accused person himself decides that, well, I can do it, examine the situation and find out whether he may not need a lawyer. So, yes, a lawyer or a counsel of his choice even starts from the very day he was arrested. But when it comes to court, I think that ideally, and especially in a situation where this is a matter which, though he was charged with an offense for which the punishment should be 5 years, and ideally is not a first-degree felony, but the other related facts make it some matter that will generate public sentiment and public discourse. And therefore, I thought that it should have been one of the appropriate instances where he should have had the benefit of a lawyer, whether one that is appointed by the court or when on the first day he appeared and he didn't have a lawyer. Probably a more appropriate procedure may have been to either adjourn it and remand him and tell him to try and arrange. Because when you listen to some of the family members, they didn't even know that the trial was coming on that day. So who was to even arrange for a lawyer for him? The legal aid opportunity is there, but somebody will have to make a phone call or go there to find out whether they can avail themselves to defend him.
I'll bring you back in. But, Doc, is this sort of thumbprinting what you've been championing about our attitude towards people who are suffering in one way or the other? And it is like we have been nationally exposed.
Well, precisely, that is really exactly what is happening. We've been taking mental health issues for granted. And once in a while, an issue comes up, and then we recognize that, what we forgot is now staring us in our face. Anybody could have been a victim. The president could have been a victim. So that is precisely what is happening. So it's an indictment on all of us as a society to raise our level of care, our level of awareness on mental health issues, what we regard as mental health. To start with, start from the family. They are saying that when he came from, he was repatriated, deported. And they thought that, and then he came with mental illness. They thought there must be something spiritual about it. How can a beloved person go abroad to go and earn some living? He comes with mental illness. Therefore, there must be some spiritual thing. So even though they may have taken, and we are not too sure, they may have taken him for orthodox treatment, the belief of a spiritual causation was so strong. And again, you can't blame him. This is where, as a society, we are guilty. We spiritualize everything. So they take him to an Okonfo traditional priest, and eventually, probably, they get fed up. Again, you can't blame them. They got fed up because maybe this guy was not doing well. Even if they took him to the Orthodox center, probably they were not getting medications, and on and off, you don't have it. And if you have to try and get it from outside, expensive. So all this is, so you can't blame them too much for probably ignoring inverted commas. And I've been hearing bashing of the relatives, why did you ignore him? I mean, there are many, many patients on the streets. They are ignored for similar reasons. And that is what is happening. And then eventually, when he's brought to the court, because of the low awareness of all of us, the police themselves, they don't recognize that there could be something wrong with him. The judge could not recognize that there could be something wrong with him. So the whole setup, we are guilty. BNI. So we are all guilty about this issue. We are not just picking a case out of this, but is to draw our attention to what we have neglected all along.
Doc, let me come in. I mean, even though we are not picking a case out of this, we can't even say whether he is or he's not. But, I mean, was his behavior not too obvious, out of the ordinary and obvious?
That is what beats our imagination. From the legal point of view, lawyer has told us there is something that beats his imagination. From the medical point of view, I can't understand why somebody would be behaving this way and you think it's perfectly normal with him. Even to the point where a friend of the court, a lawyer, has come up to draw attention that this person may be having mental illness. Therefore, let's take him for assessment. We said, no, that beats the imagination of all of us.
Doc, I mean, he's an adult, so you don't need to contact his family. You can drag him to court at any time and, you know, try him or jail him, incarcerate him without his family being aware. Is he entitled to his family being around?
Oh, well, but, I mean, these days with mobile phone and so on, at least he should be given the opportunity to call someone or ask someone to call on his behalf. I can't see how that should be a problem. I mean, he's entitled to counsel of his choice. How can he reach his counsel in the first place? Because he may not have a mobile phone, he may have been off, or he may have been taken away from him. So just the opportunity, because if all that had been done and he had been properly convicted in accordance with the law as we understand it, then all these problems and these arguments wouldn't have been the subject of any discussion currently. Because you see, it is also probably the problem of some of us as well, also as lawyers. I think we are not also helping the court to a large extent. We sit in court, accused persons are, if you like, compelled to do their own cases, and we sit there and we don't help them. I mean, it's very painful that sometimes you see that if this person had had a lawyer, the sort of questions he's asking would have been different. And let me give you an example and how serious it is. There was this gentleman, the recent case of Doji Saba, yes. His brother was convicted with the offense of murder, of course, where he was arrested. And then he went to the police station to give him food, and he was also arrested. They went through the system. He protested and protested. Eventually, he was also convicted with murder. Wow. And he fought the case till Court of Appeal, and then the conviction was overturned. He had been on death row for 11 years. You can imagine, if you've ever been to the condemned cells, you understand the trauma that you may have gone through. Now, just last month, in June, the Supreme Court has held that the state should compensate him 34,000 Ghana cedis. Even if it's one cedi, it is money coming from us. That is why it's important that, and the court said, as lawyers, as prosecution, even as the court, we should be very careful in our during the prosecution process, where everybody should give his best, because this is the money that the state could have spent on maybe just even clearing some weed from any, or even collecting dust or waste and so on to prevent this flooding and so on. So I think that it's not just the court, the prosecution, and in Ghana the prosecution believes that I must ensure that the person goes to jail by all means. That is not the concept. The concept is, as a prosecution, bring all the facts, even that may go against you, because you have all the state apparatus. The accused person's statement is with you. The lawyer may not even have it. Sometimes you press for it, and they say it's a summary trial, I won't give you. You have the complainant statement. You have all the state apparatus at your disposal. In any case, the person who is the accused person, his tax is also feeding you, also helping you to prosecute him. So in America, for example, if a prosecution or the prosecution hides some vital information from the defense or the defense lawyer, and it turns out that they had that information, and that if they had disclosed it, the accused person wouldn't have been convicted, it becomes a very serious matter. And that is one thing I don't see here, with all due respect.
I'm going to take a break here, and then when I come back, could this be the sort of courts that we are looking for these days? Swift judgment, because we are all complaining about prolonged judgment. Could this be what we are looking for? And then the numbers will be on the screen so that we hear your take, because I know this is a very emotional topic, and you want to have a say. We're coming straight back. Well, thank you very much for staying. We're talking to Dr. Osei Asare, who's the chief psychiatric, and I'm talking to Yao Opong, who's a legal practitioner. And I'm going to start with Dr. Yu. Doctor, imagine this guy came, hypothetically, and you found out, he was mentally not well. Does he automatically write to the court to say, well, set him free or leave him for me to look after?
No, we don't prescribe to the court. You will leave the judgment to the court, but we are advisors, witness.
Okay.
What we would do, supposing this patient came and we found him mentally ill, the question we would ask ourselves is, at the time of now, is he mentally ill, and therefore, is he capable of standing trial or not? If he's not capable of standing trial, then we advise the judge that he cannot stand trial now. Because before you can stand trial, you must be aware of what is happening. You must recognize the charge that has been preferred to you. You must be in a position to even challenge the jury, if you have a jury, you must be able to follow the proceedings. You must be able to plead guilty or not guilty. So if you are not in the position, by virtue of the nature of the mental illness, you cannot do this, then you will tell the court that you are not fit to stand trial. That means you need to treat you until you are put in that position. Now, assuming even that now he is capable of standing trial, you will then need to go back in history and decide that at the time of the alleged offense, was he mentally ill or not? He could have been mentally ill, but now well. You will then decide and advise the court. But even if you assume that at that time he was mentally ill, it does not necessarily mean that he is innocent. Because, as I said earlier, mental illness can affect various parts of your mental function, your mind. Now, if, as lawyers said earlier, if before you can be charged, you must be aware, to start with, the crime offense must be there. And then you must be aware, you must have the guilty mind of doing it. You must be aware of what I'm doing that is wrong. Now, if the nature of the mental illness affects or impairs your judgment, making it impossible for you to know what you're doing is wrong, then that is where then the court will say, no, he's probably not culpable. But you could be mentally ill, all right, but that faculty that determines your judgment, that determines your recognition that this is wrong, your recognition that I am guilty, if that faculty is intact, it is part of your mental illness, you will say you are legally sane.
Wow.
Mentally ill, but legally sane.
So in that case, he goes to court, gets tried, and then handed over to you or handed over to the prisons?
No, we assess and evaluate and do all this, and then advise the court. Then the court will look at the factors.
So let me briefly, Doc, so lawyer, so in this case, well, some of his faculties are not right, but he's aware of what he's doing. After that, he goes back to hospital to get completely healed, or he goes to jail?
Oh, well, I mean, first of all, the defense of insanity is what they usually refer to as a partial defense. The court will look at the circumstances in which you committed the offense and look at all the elements that are listed. And because two things, I mean, what we say generally as the mens rea, that's, as Doctor said, the criminal mind, all right, or the intent or the intention to commit the offense. If you are deprived of that, then, and it is certified that at that time, then you wouldn't have known that you had committed the offense, or you wouldn't have known that you have breached any law or you have violated any law. So depending on the circumstances, the gravity of the offense, the complexity of the offense, then the court will come to a decision whether that defense will avail you and whether it should even be the partial defense or maybe absolute, as the circumstances of the special case may be. So it is not just a straightforward matter. It is like intoxication is also another partial defense.
Let me push you quick before I can get the callers in. Now, according to this statute which this guy has been charged with, the maximum he should get is 5 years.
That's right.
But this guy's been given 10 years.
That's right.
What could be the explanation? Is it because of the personality involved, therefore it gives you the leeway to stretch, or?
I would just permit me just to refer to something because you spoke about the personalities. From this Republic versus Kwabena Manit, alias Tagore, and another, that I wish to stress, and this was Justice Yaupel, I wish to stress, and with much importance, that this duty to prove charges leveled against another beyond reasonable doubt is a standard one. The principle that underlie this duty and how it has to be accomplished are the same. They do not change according to the status or disposition of either the accused person or the complainant involved. Neither do they change according to the charges preferred, nor the public perception, concern, or reaction in respect of the offense and or the accused person in question. So that doesn't matter. The law usually will give a judge the ceiling. So this one, the words used is that it shall not exceed 5 years. You may even find him, old Ghana cedis 5 million, or both. But you don't have the jurisdiction to exceed the 5 years.
So has his rights been violated?
Oh yes, for me, I think it is close to that. Of course, I mean, even if the procedure is okay, and if my understanding of this law is correct, then I think it's one of the cases where an appellate court can easily set aside. But you see, there is, and today when you look at the, you listen, people are now thinking that he was charged with preparation to commit an offense to wit murdering someone. Let me use the word someone advisedly. Yeah. That wasn't the matter that was before the court at all. Not the charge sheet, not even the facts. All that was said is that he was found in his possession firearms without excuse or authorization, meaning that it had not been licensed for him. So any other matters won't come in. But we know that under Section 154 of the Criminal Act 30, a court can convict a person in a very limited sense if there are a set of facts for which the accused is charged. But flowing from it, there could be some minor offenses. All right? Mm-hmm. You can also convict him on that one if it's proved. But you cannot, if the second offense is higher, or the punishment for it is higher than the one he is charged, then you don't have the jurisdiction to do so.
So like driving on a pavement and running down a pedestrian.
Yes.
So running down the pedestrian now comes over me driving over the pavement.
You can't do that. But then the two can flow from. So if you are charged with maybe reckless driving or careless driving, one, you run through the traffic light and you also let's say destroy one of the traffic lights, the poles and all that. Destruction of public property can be one. And then the fact that you also drove recklessly or carelessly. But the second one, and then you were just charged with the fact that you drove through the red light, for example. If the second one of destroying the property, the punishment for it is higher, but you were not charged with it, the court doesn't have jurisdiction. So when he was brought before the court.
If you don't bring that charge before the court can't say, oh, hold on, he destroyed the traffic light, so let's use that.
That's what I'm saying. Unless it flows from, this one, it flows from it. But if the punishment for the destruction of the traffic light is higher, then it means that that other offense is not a lesser offense. And you cannot. So in this one, when he was brought before the court with a lesser offense as compared to the one for which he was given 10 years, the court, once again, with all due respect, didn't have jurisdiction to punish him for those set of facts which may also ground a different offense, but for which the punishment is higher than this one. But clearly, as I said, he was charged, first of all, with under Act 190, Section 190.
Put the phone number on screen. Let's get a couple of calls. Mr. Producer, put the number on the screen. Let's get a couple of calls and let's see what people are, saying, or maybe somebody may have a question that I haven't asked. But
so what I want us to just understand and accept is that at the point in time in the court, he had not been charged with attempting to kill anybody. He had not been charged with preparation to commit an offense, or with murder or any such offense. All that he was charged with before the court, and the facts brought before the court, were that he was found in his possession arms which had not been, if you like, licensed in his name. That's all.
So this is it for this man, right? 10 years. And until some philanthropist lawyer comes from somewhere, he's doomed.
Oh, well, I mean, but what we should be careful about, if we are not careful, we'll be continuing to pay compensation as this Doji Saba one. Okay, but I think that in future, we should be putting our minds on these things, so that if anybody deliberately or maybe negligently, and it can be proved, caused a thing like this, for which we should pay compensation, then we have to look at.
Let me speak to Zaro. Hello, Zaro.
Hello.
Yes, Zaro. Let me hear your take on this issue.
Yes. Good evening.
Good evening.
This is Byron from Wa.
Yeah.
Yes, I'm not a lawyer, and I'm not a doctor as well.
You're like me then.
But my problem is that, yes, I'm like you, Chief. And we have failed as a nation to investigate, to to see, one, whether the gentleman has partners. Two, whether somebody sent him. Three, whether somebody is to benefit from the Gentleman's Act. And finally, my worry is that the judge, in fact, did not show a little human for the guy. Why I'm saying so, at least let us investigate to see whether the gentleman is mentally fit to commit the act.
Zion, you made your point. Let me speak to William now. Hello, William.
Hello, good evening.
Good evening, William.
Yes. Thanks for the opportunity. And I think this is a very fruitful discussion that is enlightening us on this subject. My worry is just about what the first caller just said. I thought that the case wouldn't have been hurriedly handled the way it was, so that we would have gotten more information, just like the caller said, to know what was the motive behind. I mean, behind what the man has told the court. Was there any faulty were there any faulty somewhere that could have taken influence? They could have given us even more information to what has happened. But having said that, I want to find out from Dr.
Osei.
Yes, on such issues, he's telling us that they are able to determine whether the person is actually mentally ill or the person is just pretending. Now, if under this circumstance, we also have a lawyer in the studio, the two of them looking at this issue, is it something that they can come together to let us know whether they can go and now seek justice for this man, or let the issue be investigated proper, and then we get to know if there could be an appeal.
William, thank you very much. And Thomas, make it snappy. There are lots of people on the call. Let me just make it snappy for me. Hello, Thomas. Thomas, have I got you?
Yes, sir.
Very good, Thomas. Make it snappy for me. What's your concern?
Good evening.
Good evening, my boss.
Yeah, my issue is, if he had perpetrated the offense,
yeah,
what would be the crime?
Well,
would you what would be? I want the lawyer. I want the doctor to answer this question.
The doctor or the lawyer?
The doctor.
The doctor. Okay.
The psychiatric doctor.
The psychiatric doctor. That's a difficult one for him. But who's my next caller? Adamuda.
Good evening.
Good evening, Adamuda.
Yeah, thank you very much, Nana, and your panelists for the wonderful work you're doing. My first question is, what could police do a psychiatric test before presenting the man to the court? The second issue, like Zion was suggesting, I think that somebody might have sent security broke down somewhere. Who was that security person who directed that guy to the president's church? He has his narration. He has been there several times and he's been directed to go to the church. So what is happening? We want to know. The investigation should still continue. We want to know the facts. Maybe people surrounding the president or the security details may have even been involved in this. And let's not forget that Kennedy Japan raised another issue that even the security detail that was going to take over attempted some time ago to also stage a coup against the president.
Okay, we can't substantiate that, so let me drop that. And Vincent is going to be my last call because I ran out of time, and then I get a gentleman, give them the last word. Hello, Vincent. Have I got Vincent?
Yeah, hello.
Very good, Vincent. What's your concern?
Okay.
Yeah. Vincent, let's hear you.
I'm finding it difficult to understand the whole. Yeah, I'm finding it difficult to understand the whole issue.
Just like me.
Because we don't know whether it is true that the gun that the man was using was fully loaded. and then whether it's true, because when you see the man inside the car, the way that the man was talking, it shows that the man was insane.
Well, Vincent, thank you. That's the big debate as to whether he was making it up, insane. Maybe that's how he reacts. But until he has gone to see Doctor, briefly, Samia,
yes,
for me, a couple of questions for you.
From what both of them, their opinion, there's something we call agent of provocation, a giant provocateur in law. Somebody could have procured this man to commit an offense. You can even procure a dog to commit an offense. So he may not be of a sound mind, or he may be insane and deprived of the intent. Somebody else could have procured him to do it, and that would have become the offense committed by that other person. Yes, so that possibility is there. But I think the security issues, don't forget that if it's true, I hear the Chief Justice also attend that same church. Just last week, a very strange story which most people didn't attract attention,
so I give Dr.
where we're told that at the court premises, somebody was able to take some of the parts from the Chief Justice's own vehicle.
Wow.
And he was on remand. So I think this should be a wake-up call, though a painful one, that we should put more into security for especially our leaders and all of us in addition.
Doc, let me give you the last word.
Yeah, a question was asked that if he had succeeded in killing the president, what would have happened? I think the same point that we are raising, that in any case, whether if he had succeeded or even now, he should have been brought and should be brought for evaluation. And thereafter, as you've enumerated, then the court will take it up. But people want to know, so now what do we do? We now have a new law, Mental Health Act, which establishes mental health authority. The authority now has the responsibility to be interested in all persons with mental illness. In addition to promoting mental health, to be responsible for all persons with mental illness. And the authority will now look at this one, liaise with the lawyer, and see what kind of advice. One of the options the authority could do will be to spearhead an appeal or write formally to the Chief Justice or Judicial Secretary, or come up with such a statement. But obviously, you take it up. This will not end here.
Could he be a risk to himself and to inmates? Briefly.
That is the danger. If he's really mentally ill, with the delusion, wishing to kill, obviously he's likely to go and complete the thought. So somebody might die as a result of our...
Well, thank you very much.
May abandon him, and that will worsen his situation.
Well, thank you very much. That's all time will allow us, but we wish we had more time to discuss it. But it's very intriguing, isn't it? More questions than we have answers. Anyway, on Thursdays, for all of you who follow my show, that's my opinion. Tomorrow, I'm looking at the effects of bad publication on Ghana to the outside world. The effects of bad publication on Ghana to the outside world. It's going to be a very intriguing piece between 2 and 3 p.m. Tune in to Joy FM 99.7 and listen. And that's Thursday afternoon. And I want to say thank you to Tantiz, who sews my shirts for the show. And you can read Tantiz fashion on 024-366-2001. 024-366-2001. I want to say a big thank you to Dr. Osei Asare for making time out this ungodly hour to come and educate us. I want to say thank you very much to our friend, Lawyer Opon, for coming to the show to also educate us. Folks, my name is Nana Ansakwa. This is PM Express, and tomorrow we'll be back to do this all over again. Gentlemen, thank you very much.
You're welcome. My pleasure.